Welcome back to another edition of Between Two FARS. I'm Warneke Miller here once again with Robert Tepfer, our veteran procurement attorney with close to 45 years of procurement experience. And he is talking through some issues today regarding deadlines in litigation. This is going to be a very functional episode. If you've not done any litigation before, particularly litigation in front of the ASBCA, it may not occur to you what sort of things you need to consider when you're given a deadline or a timeline to complete discovery or a briefing. So we just want to take some time today and talk through the nuts and bolts of how you allocate your time during the litigation process. Bob, what are some helpful pointers, tips that people should keep in mind?
Well, a lot depends on what forum you're in, but I've had program directors who have a lot of power in our world. When we get a specific court order, discovery request, whatever, particularly in federal court, say, well, we're going to have to slide that to the right. And I'd have to sit down and say, the old adage that a king never dreamed of the power of a federal judge. And, we will make that date or have a very good reason. And a lot of times you have to educate them that there's not the flexibility that they're used to, that they can't drive a lot of things. At a minimum, you're going to have to go back, and that's not going to be fun, or you're not going to do it very often because you're going to have credibility. So you need to make certain that people are educated as to the significance of these deadlines. That's one thing. And if you're the lawyer involved, one of the things you have to understand is the folks on the other side may not have an appreciation of how to respond to whether or not it be a document request or interrogatories, and they're going to do the very best that they can, but you don't give them all your time, because if you do, and you may end up waking up with only a day or two left, and then you have to get it to the right people, or you have to rewrite everything, or you need to get more facts, or they just don't believe you and they decide they're going to respond to their boss, who they're going to have to live with long past this case, who said slide it to the right, and they're not going to do it by that deadline. You need to make certain that you have a deadline that gives you an opportunity to recover from any one of those bad things occurring, and which means don't give away all your time. Okay, if they ask you when it's due, you tell them the date that it's due to you. Okay, I've got to have it by this date. They don't need to understand necessarily all the other things, because they'll actually thank you if you prevail in the case. Okay, but you have a right to go back in. You have an obligation to go back in and rewrite things or ask further questions or get the right person involved. And to do that may require more time. So don't give away all your time is the rule that I would get into and explain to them.
So if you had a hypothetical filing due in front of the ASBCA, let's say the judge has given you a deadline for a summary judgment motion, and it has to be filed in the next 45 days. Bob, how would you divide up that 45 days? What are the phases of preparing the summary judgment motion, and what deadlines do you give to the people involved in this?
Well, I need to make certain under Rule 11 that everything is going to be accurate to the best of my knowledge. So I need to have the factual basis outlined, and I need to make certain of all those facts before I can even really write it. Okay, and then I have to go back in and make certain that there's what those facts in dispute and those are not. Okay, so I'm going to have to give them maybe a week or two to give me those facts, because I may have to get with opposing counsel to go over the issues of what's in dispute and what's not. Okay, then on those instances where, I may not have enough information, I may have to get that information in the form of documents or whatever, but I won't know that when I first get a response from them. So, it's going to be iterative. I'm going to have the first iteration be maybe, 10, 15 days of, tell me answers to these questions to support in any kind of allegations that I need to have. Then I'm going to have, okay, I want to make certain that I don't undermine my credibility. What documents, what conversations, what events can you speak to that will support each of those things? Those are going to require meetings. Theoretically, you may have to sit the whole group down because the collective knowledge of the people involved is a lot better than individual emails or phone conversations where Betty can tell Joe, no, you weren't there that week. I had to do that, and this is what really happened, or vice versa. That kind of a dialogue can be very critical because you don't want to make arguments that are later at the hearing or, wherever are inconsistent, where your story evolved from one motion to the hearing and all of a sudden you're arguing different things. So, that would be maybe the next 10, 20 days. And then you want to be able to have, 20 days where you actually get to work on it. Okay, because it never goes perfect and you're going to have to get with people again. And then we all know that from time to time, headquarters in their wisdom wants to examine things. They may have their own questions involved and you're going to answer them and you're going to be the person that's subjected to all of that.
Yes, the supervisory review is a very important component of any preparation for litigation documents, and make sure you build in time at the end to be able to have the appropriate parties review the work before it can be filed. And that's going to differ situation by situation, but understand who's expecting to see this document before it's filed and build their review into your timeline.
One of the biggest headaches that you could run into is if this whole production takes 60 days, is who's going on leave. And that, becomes a personal thing because, Mary's spouse has big plans and the timeshare only during that week, and Joe's mother is ill. And so, you have to juggle those things. Best that you're aware of those things and you explain to them the timeline and the importance of these various iterations early on. Yes. So that people don't become unavailable. You might say, well, I can talk to them on the phone and get answers to those questions. But if they want to show you documents, emails, whatever, they're not going to necessarily be able to access them. Another thing that you're going to have to weave into this entire process is if you go so far as to send emails back and forth, you have to make absolutely certain that they protect what's attorney-client privilege and what's work product, and that you don't effectively lose that by them passing that around to people that are not involved in a lawsuit or very tangential. So you need to have a very committed group that understands the significance of what they're dealing with.
In terms of timelines, there's one other caveat I want to throw out there, and that's the transmission of your final document to the litigation unit, whether it's a GAO or ASPCA or district court. You need to understand, even in this electronic age, that there can be delays. Systems can be down. You may have trouble uploading something or compiling a PDF. Build in time for that. One of the things I've always done is I've aimed to get it filed 24 hours before it's due, just because you don't know when something's going to go down. And if it's on your end that it goes down, there's not going to be a whole lot of mercy from the court.
Yeah, I mean, invariably, that's why you don't give away time at various stages that you can keep, because something will go wrong. Yeah. And if you don't have any recovery time, or you've just placed everything down that this, I'll get this on this date and it'll all go perfect and everything, it won't. And the consequence, as you point out, will be your own on you.
Yeah. All right. Any other issues with deadlines and scheduling that you think we need to scare our poor audience with?
No, so much of this, I mean, it's fact specific, but I mean, let's say in the first 20 days you send out things and ask for people to respond to, what you're going to put down in the summary judgment. You may find out that that individual is on leave, or they're there, but they say they don't know anything about it, and the person who is on leave.
Yes.
the availability becomes critical, and there's nothing you can do about it. And folks routinely start out every litigation is saying this now is in the hands of the lawyers. It's not my problem. And they don't understand, oh yes, I'm your helper, but it is definitely something that you're going to be working on and responsible for.
As you can see, organizing and being prepared for the unpredictable are very important when you're planning to file a litigation brief or any litigation document. As Bob always says, a little paranoia is good for you.
Absolutely.
See you again next time on Between Two FARS.